So welcome to this, our final day together for the World Indigenous Law Conference. And to begin our day, I have asked our sisters Evie and Elle to begin us in a good way.
Amishpancinco no wanyolke, kualioali, no toca ocelosochi iwan ikanawat, tlasokamati, no wanyolke tongva, iwan ahachman. Good morning, everybody. My name is Evie Aguirre in English. I introduced myself in my language, and I asked our sister here if she would come up with me. And I asked her permission to offer a song this morning. And I'd like to thank her and her people and the Tongva people for opening up their home to us and allowing us to meet on this territory. So I'm going to offer a song this morning, and just to give a little explanation of our song, it's a song that we usually sing at the beginning of our ceremony, and though we're coming to the end of our conference, I feel it was appropriate because the song is kind of like a beginning of a renewal of what our mission is as Indigenous peoples. And like our brother Chase had said, we've all gotten to this place for a reason, whether we're here to give or to receive something. And so the song is to the Creator, and it asks for him to watch over us. It says that this is the place of where the essence of our ancestors, their knowledge and wisdom and love flows. And it really is meant to be sung wherever that essence is, and that essence is carried within us and within all of you. And it also asks that he assist us in not stumbling. And it's very difficult to translate it into English to make it sound kind of like, our language is very poetic, as many native languages are, and it's very difficult to translate it into English without it sounding technical, I guess. So it's asking the Creator to watch over us, and that may we not stumble in our life and stumble in our ways and how we're living this world as Indigenous peoples. So thank you.
Good morning. Here we are in our final morning together as part of this convening, and I want to begin by saying thank you. Thank you to all of you, advocates and thought leaders that have come from all around the world to be here today. I've learned so much, and I appreciate it, and I'm honored to be part of this convening. My role today here is to introduce Dean Erwin Chemerinsky, who will be speaking to us for a bit this morning. Dean Chemerinsky is the Dean of the Law School here at UCI and also the Raymond Pike Professor of First Amendment Law. I'm not the only one that would tell you that Dean Chemerinsky is the leading expert on constitutional law and doctrine in the United States. One of his most recent books, The Case Against the Supreme Court, as I read it, tries to make a case against the faith that a lot of American lawyers have in the court as a kind of oracle of truth and justice. And for me, my mind connects that work to the work of Walter Echohawk in his book, Courts of the Conqueror. And as I was saying to both of them earlier this morning, if there's ever a revised edition of the Dean's brief against the Supreme Court, I think some of the cases that Walter Echohawk describes might be in that second edition. The Dean has also had a really impressive career as a practicing attorney on behalf of causes for social justice. And today he's going to speak a little bit about his experience and about the way forward with the Supreme Court. And so we, based on our own experiences, may find some points of comparison and also some points of contrast with what the Dean will share with us today. With that, I'd like to ask you all to join me in welcoming Dean Erwin Chemerinsky.
Thank you so much for that kind introduction and the warm welcome. It's truly my great honor to be with you this morning. I want to echo what Seth said in thanking all of you for being here. I want to welcome you to the University of California, Irvine. And I want to take a moment and thank my terrific colleague, Seth Davis, for all of his tremendous hard work with regard to this conference. It's time to dream. It's time to dream what it might mean to have a progressive Supreme Court that cares about the rights of indigenous people, that cares about the rights of all minorities. So rarely in American history have there been major shifts in the ideology of the Supreme Court. From the 1880s to 1936, the court was dominated by very conservative justices. The court repeatedly struck down progressive laws, like the first federal law limiting child labor, like state laws requiring that a minimum wage be passed. Over 200 federal, state, and local progressive laws were declared unconstitutional during this period. From the late 1930s until 1969, there was always a court that was dominated by justices appointed by Democratic presidents, especially during the era where Earl Warren was Chief Justice. The Supreme Court struck down the laws that required racial segregation. The court applied the Bill of Rights to state and local governments. The court expanded the rights of criminal defendants. The court tremendously increased voting rights. But since 1969, there have always been at least 5 justices, and sometimes as many as 8 appointed by Republican presidents. The court has hardly been a force for progressive change, whether for the indigenous peoples, for any other group. Now, though, the court is poised where there could be a dramatic shift in its ideology. There are now 4 justices who have been appointed by Republican presidents and 4 who were appointed by Democratic presidents. And this is not simply about the vacancy created by the death of Justice Antonin Scalia on February 13th of this year. Since 1960, 78 years old is the average age at which Supreme Court justice left the bench. There are now 3 justices, 78 or older. Ruth Bader Ginsburg turned 83, on March 16th of this year. Anthony Kennedy turned 80 on July 23rd. Stephen Breyer turned 78 on August 15th. Especially if the next president serves 2 terms, he or she is likely to have as many as 4 seats to fill on the United States Supreme Court. What might that mean? What could it mean to have a progressive Supreme Court for the issues that everyone in this room cares about? Now, you might ask, if we care about social change, why should we focus on the Supreme Court? After all, through much of American history, the Supreme Court has been repressive and upheld repressive government actions against Native Americans and against others. I think it's important in this country to focus on the Supreme Court because often if there's going to be any protection for the powerless, it's going to have to come from the judiciary. When's the last time that a state legislature adopted a law to expand the rights of criminal defendants? When's the last time that a state legislature on its own adopted a law to give more rights to those who are imprisoned? Those who are minorities often have to turn not to the majority in society for protection, but to the judiciary. And a progressive court could make that possible. So when I challenge all of us to dream about what a progressive court might mean, let me try to be specific about some of the things that could happen in the years ahead, things that all of us could work for. One would be a court committed to ending inhumane punishments. The United States is one of the only 9 countries in the world where the death penalty is still carried out. No Western nation other than the United States still has the death penalty. If you look at an Amnesty International report from 2014, it lists the other countries where capital punishment is imposed. There are nations like North Korea, China, Libya, Somalia, Iran. I believe there are 4 justices on the current Supreme Court that would declare the death penalty unconstitutional if only they had a 5th vote. Inhumane punishment, though, goes beyond just the death penalty. Both the federal government in 44 states impose prolonged solitary confinement as a punishment, where individuals are kept with no contact to other human beings between 22 and 24 hours a day for prolonged stretches of time. Every study has shown what that does to the human psyche and why it's cruel and unusual punishment. Second, we can imagine a court that's committed to racial justice. Through so much of American history, the Supreme Court has had a terrible record with regard to racial justice. Terrible record in the area of Indian law, a terrible record with regard to equality for African Americans and Latinos. One of the important obstacles to racial justice in the Supreme Court is that over the last 40 years, the Supreme Court has said that there's only a denial of equal protection if there's proof of intentional government discrimination. It's so hard to prove intentional discrimination. Rarely will government officials express a racist motive. And so, government actions that have a tremendous discriminatory effect against all types of racial minorities cannot be challenged. The Supreme Court has said, even in the face of proof of enormous racial disparity in the imposition of the death penalty, in hiring for government jobs and in voting, there was no constitutional violation. We can hope that a progressive court will say that proof of a discriminatory effect against a minority, any minority, is sufficient basis for a constitutional violation. Third, if there's a progressive court, we could hope it's one that would lessen the control of government by special interests and by the wealthy in our society. For the last 40 years, the United States Supreme Court has said that rich people have the constitutional right to spend as much as they want in election campaigns to get the candidates of their choice elected and the ones they oppose defeated. Citizens United versus Federal Election Commission in 2010 is an example of this. There, the court said that corporations, too, have the right to spend as much as they want against elected or defeated. This truly creates government that serves the special interests, government that serves the interests of the rich. I would hope that a progressive Supreme Court would go back to decisions from 40 years ago and reconsider the premise where the court said that spending money is a form of speech, where the court said that the wealthy have the right to spend as much as they want in the context of election campaigns. When the wealthy, when corporations spend huge amounts of money to get candidates elected, they do so with the expectation that once elected, those individuals will serve their interests. If nothing else, it always creates the appearance of corruption in government, and so often creates that reality. It means that the voices of people that don't have those resources are drowned out in the election process. Fourth, I would hope that a progressive court be committed to economic justice. There are tremendous wealth inequalities in our society that everyone here is familiar with. Wealth inequalities that affect Native Americans and Indigenous people in the United States. Wealth inequalities that affect all racial minorities. I think one of the worst Supreme Court cases in my lifetime, and it may not be familiar to you, was a decision in 1973, San Antonio Board of Education versus Rodriguez. There, the Supreme Court held that great disparities in school funding, even in the same metropolitan area, don't violate the Constitution. In that case, the Supreme Court said that there's no right to education under the United States Constitution. And it might surprise you to hear that. The Supreme Court later reaffirmed there is no right to education under the United States Constitution for anyone. The Supreme Court there said that discrimination against the poor doesn't violate the Constitution. I would hope that a progressive Supreme Court at the very least would say that every child has a right to an adequate education. Literacy must be regarded as a fundamental right. If ever we will be a more equal society, it has to be through education. But I would hope that a progressive Supreme Court would go further than that and find that discrimination against the poor is a basis for a claim under the Constitution. Fifth, I would hope that a progressive Supreme Court would open the courthouse doors to those who have suffered violation of their rights. Over the last half century, the Supreme Court, through a whole series of doctrines and decisions, has meant that those who are injured can't get their day in court. The Supreme Court has made it almost impossible to sue state and local governments, even when they egregiously violate people's rights. Did you know that if a police officer commits perjury on the witness stand, and it leads to the conviction of an innocent person, that police officer cannot be sued for money damages? Did you know that if the prosecutor intentionally uses that perjured testimony, and it leads to the imprisonment of an injured individual, a wrongly convicted individual, that prosecutor can't be sued for money damages? And in all likelihood, nor can the local government that employs the prosecutor, and certainly not the state government. To pick another example, in almost every employment contract now, in almost every consumer contract, there's a clause that says that you have to go to arbitration. You can't sue in court. And the Supreme Court has so aggressively enforced those clauses to keep injured people from ever having their claims heard by a judge. I hope that a progressive court would open the courthouse doors to those who have been injured. So many of the restrictions that I've just described to you were in 5-4 decisions from the court. it won't take much in changing the composition of the court so as to achieve the kind of results that I'm talking about. I realize that these changes will not be easy. It's going to require that we put real pressure on senators to put forward progressives for federal court positions, pressure on the president to appoint progressives to the Supreme Court, and to fill vacancies at courts at all levels. But I am here to say that I believe there is the opportunity for dramatic change. And if we don't seize it now, it might not be there for decades to come. So that's why I want to come before you and say that I think it's time to dream. I went to law school for 40 years ago now because I believed that law was the most powerful tool for social change. I still believe that. Social change is much more difficult than I could have imagined when I was a law student over 40 years ago. But I believe that if all of us and our allies work together, we really can make these progressive changes happen. It's time to dream. Thank you.
Applause for the Dean. Well, it gives me great honor to introduce our keynote speaker for this morning, a longtime friend of mine. He currently serves as the Chief Justice for the Supreme Court of the Kickapoo Tribe. He's on counsel for Crown and Dunville of Oklahoma, the largest and the oldest law firm. He serves as the chair of the Board of Directors for the Association for Tribal Archives, Libraries, and Museums. He's a published author and renowned professor of law. He authored most recently In the Light of Justice, The Rise of Human Rights in Native America and the UN Declaration of Indigenous Peoples in 2015. In the Courts of a Conqueror, the 10 worst Indian lawsuits ever decided. One of those lawsuits happened to be from our community at home. Battlefields and Burial Grounds in 1994. He's a recipient of many honors and recognitions. I've come to know this person when I happened to serve on the steering committee for Native American Rights Fund. He was a staff attorney, and in that capacity litigated many significant cases that's at precedence in the United States Supreme Court and all over. So I'd like to introduce Mr. Walter Echohawk.
Noa akitaru, iriwe turahe, waitatu dediku, titiri tatu pakararu. Good morning, everyone. Chris, thank you for that very kind and generous introduction. Dean, thank you for your wonderful remarks. I agree with you. This is a time to dream, and that is going to dovetail with what I hope to convey here in my time at the podium. But I want to congratulate at the outset and commend the Seventh Generation Fund for putting this wonderful conference together. I've been a big fan and admired the work of the Seventh Generation, for many years. And it's my prayer that the Great Spirit will continue to be by your side as you go forward in your important work with this wonderful board that you have. And so I also want to thank each and every one of you for coming to this wonderful gathering, and especially to join the seventh generation in welcoming our visitors, especially from other nations that have come so far to attend. And I am so glad that I was able to attend. I'm grateful for my opportunity. I'm thankful for my opportunity to listen to these words of wisdom that we've heard over the past few days. I feel like I've benefited greatly in my own life, in my own thinking, and I'm especially grateful for the elders that are teachers that opened this conference, with Henry and Orrin Lyons, are listening to the words of our wonderful ladies from Africa and their wise words of wisdom that they shared from this podium. And I was inspired, by our young leaders that came forward, Chase Iron Eyes, I feel like our legal future is in good hands, with this new generation of Native American attorneys, with these young singers that from Yurok singers that came up here. I think the future is in good hands with this next generation. And so I was very inspired by our young people that were here today. And this conference, has presented many important issues affecting Indigenous well-being, dignity, and survival. I thought it was very, very appropriate to begin the conference as it did with our discussion of our traditional laws that we have is our legacy as Indigenous peoples. And it was very, very interesting to me to listen to the presentations on the rights of Mother Earth. I think that battle to protect Mother Earth makes all of our other aspirations and endeavors pale in significance as we try to meet our environmental crises. And I also appreciated the discussions on genocide, the G word, which is very, very troubling, to look at the truths, the hard truths, about genocide, and its impact on our native peoples around the world. And I enjoyed listening to the doctrine of discovery, this unjust legal doctrine that most of us live under in our legal frameworks. And I was also thankful and to listen to many of the Indigenous struggles around the world that have been talked about over the past few days. And so we have many issues and we have many challenges that sit before us. And I think it's my role today, as I understand it, is simply to offer one attorney's perspectives on the issues and challenges that lie before us as Indigenous peoples. And I'm going to do my best in the time that I have to share my own perspectives as a lawyer that has been engaged in Indigenous rights here in the United States since 1973. I've had a great privilege in my career to be one of the many legal foot soldiers in our tribal sovereignty movement that has worked, upon the rise of our modern Indian nations that we have witnessed here since 1970 and the inception of our Indian self-determination policy. But I have to, and a lot of my focus will be on that work here in the United States because I'm simply a domestic practitioner of law here in the United States. I have no international legal experience. I've never been to the UN. I've never been to Geneva, never represented a client in some of our international forums. My practice has been confined to our courts here in the United States and the legal framework for Native American rights here in our own country. And so, but I hope to share some perspectives on, I think, the issues that lie before us that affect attorneys here in the United States and hopefully may have some relevance to the countries that you come from as well. As we look forward in the coming years and the coming generation to the domestication of international human rights law, to integrate that and import it and into our domestic legal frameworks, that is ushered into us by the landmark UN Declaration on the Rights of Indigenous Peoples. It brings all of us through the many hard work of a lot of our elders that were here and others that have worked for 20 years on this UN Declaration. And now we stand at the brink of a brand new framework for defining the rights of the world's indigenous peoples, the human rights framework. And so I want to talk about that. My topic this morning is strategic law development, the challenge for indigenous rights attorneys. And the premise of my talk is that, as I mentioned earlier, our indigenous aspirations across the world and that were discussed here today and this week are many. And our challenges are great. But at the same time, I'm very optimistic. I'm very optimistic that our aspirations can be attained, that our challenges can be surmounted by this generation in our lifetimes. I contend, and my talk will contend, that this is a historic time for indigenous peoples because the winds of change are blowing. And today, even though we can see big challenges ahead, we know that our ways of life depend on meeting those challenges and achieving the full measure of indigenous rights or indigenous justice in each country around the world where indigenous peoples live. But I'm very optimistic that this challenge can be done because I feel like, thanks to the indigenous international human rights movement, that our native peoples are poised, maybe as never before, to meet these challenges, to meet the challenges of our day. And as we look ahead to addressing these challenges that have been talked about here, I think we can know that our quest for indigenous justice, or the quest for justice, is universal. It's as old as the human race itself, because against systematic oppression down through the ages, the human experience is clear. Life is intolerable in an unjust system. And it's the redress of injustice that is by itself a value that gives rise to the great social movements seen in world history. And so these are age-old axioms that I think are strongly present in our struggle for indigenous justice around the world, and even here in the United States, the world's so-called leading democracy in a nation that prides itself on its human rights legacy. We as Native peoples in this country face big challenges in the years ahead to achieve the full measure of Indigenous human rights here in the United States. So what I would like to do in the time that I have up here is to begin looking at some of the implementation issues for achieving our Indigenous aspirations. And I want to just share my thoughts and perspectives as one legal advocate on that. And I want to cover, if I may, 4 areas with you. First, I want to look at, very briefly, the 2 legal frameworks now that we now have for looking at Indigenous rights. The current legal system that we've inherited from the law of colonialism and made the best of as in our aspirations to date. And the second is the brand new human rights framework that we can see out on the horizon, that we can see coming our way. Secondly, I'd like to try to identify what I think is the paramount challenge for lawyers in strengthening the law or the legal framework for Indigenous rights in the 21st century. Thirdly, I would like to talk about a little bit or examine what I consider to be the advocacy problem confronting Indigenous rights attorneys here in the United States and perhaps in other countries as well. To talk about the concept of strategic law or strategic law development, or especially large-scale strategic law development, where we in our practice of the law should not be constrained to represent our Native clients as business as usual, but to try to rise above and look at the bigger picture that I think is called for by attorneys acting as social engineers. And then fourth and finally, I would like to look at a couple case studies of legal social movements that I think many of us are familiar with here in the U.S., the African American stride towards equality under the law, from Plessy v. Ferguson all the way to Brown v. Board of Education, which is a good example of large-scale strategic law development that has a lot of parallels, I think, to the march to justice that I think lays before us. And the second, I'd like to look also at the Native American tribal sovereignty movement as the second case study here. That march towards Indian self-determination here in the United States over the past couple generations. As case studies that we can look at and maybe draw some lessons from as we put together the elements for a campaign to enter into the human rights era. So these are the things that I wanted to talk about here. And I'll just turn to my first task, and that is to look very briefly at the legal framework for Indigenous rights. As I mentioned earlier, we can now very clearly see 2 legal frameworks for defining and protecting Indigenous rights, I think, across the world. The first being the existing framework, that is the current legal framework that we live under, the old legal framework that is derived from the law, International Law of Colonialism. We can still see the deep imprints of that body of law in many, many countries around the world where we live under. And the second legal framework is this brand new human rights framework that I mentioned earlier. That comes to us from the modern body of international human rights law, as seen in this UN Declaration on the Rights of Indigenous Peoples. And it seems to me that in looking at these two legal frameworks, that our task in this generation and the coming generation is to save the very best features from the old framework, if there are any, the most protective features that can be found within our existing legal framework, and to merge that with this brand new human rights framework in each nation to create a seamless, strengthened, more just, more reliable body of law for defining the rights of our indigenous peoples and for protecting those rights. That, it seems to me, is our number one challenge as indigenous advocates, as tribal leaders with vision, our political leaders, is to try to negotiate the difference between the old framework and the new one to create a new, stronger body of law. So I want to spend a minute or two looking at the current legal framework with a caveat that I'm only have experience in the legal framework for Native American rights here in the United States. I haven't had the opportunity to study the legal framework in other nations, but I hope that some of my remarks on the current legal framework might have some relevance to your situation in other countries, because most of the world is, the legal framework for Native people has been derived from the International Law of Colonialism. We saw that in the presentations on the doctrine of discovery and the Johnson v. McIntosh decision that's relied upon by just about every legal system of former British colonies around the world. This is a International Law of Colonialism, as was said, is a Eurocentric body of law with origins in the dark ages of medieval Europe. And this body of law that gave birth to our current legal framework has definite anti-indigenous functions and anti-indigenous features in it. Because after all, this legal framework was utilized to legalize colonization of other lands, to legalize the appropriation of Indian land and natural resources. It was used to legalize the subjugation and governance of indigenous peoples. And it rests upon a number of very dark, nefarious legal principles, legal doctrines, such as the doctrines of discovery, the doctrines of conquest, legal notions of racism, notions of plenary power, notions of unfettered guardianship over Native people as a way to govern them. And these are pretty dark principles that come to us from a dark place, I think, in the human spirit. They're very nefarious values. And the application of this body of law around the world served to basically make everything perfectly legal that was done to our Native people from 1492 basically down to the present day. These values and these legal principles are inherently discriminatory, it seems to me. They produce inadequate legal protections, sometimes no protections at all. At worst, can be used literally as a tool to strip away Native rights. And whatever rights we do have under that body of law, at least here in the United States and perhaps other countries, our rights remain ever vulnerable because they're subject to being divested or stripped away at the unilateral whim of the government. And it produces hard-to-solve social ills seen in our tribal communities, which are the end products of this legal system. And at least here in the United States, the current legal system, that is federal Indian law, which is what we call it, is entirely bereft of the human rights principle. When the Supreme Court laid down these decisions defining Native American rights, it expressly said, we can't look to principles of justice. We can't get involved in questions of morality. We just have to take the law as we find it, which was International Law of Colonialism, and apply that to the condition of the Native people in our country. So the courts expressly eschew notions of justice, morality, human rights. And so we have a body of law that is essentially an amoral body of law without any human rights in it. And it's my contention that indigenous peoples can only advance so far in their aspirations under an unjust legal system. And to advance any further in our aspirations, at some point we have to turn and conduct a frontal assault on the unjust aspects of our legal systems in order to go any further in our aspirations. The United States here is a very good example of, I think, this axiom and the idea that our legal framework came from the old International Law of Colonialism. We need to only look at the Marshall Trilogy, which was developed by our Supreme Court in the 1820s and early 30s for defining Native American rights, which looked to, those cases eschewed principles of justice and looked to the body of International Law of Colonialism and imported these legal notions in whole cloth for defining the rights of Native peoples in our country through the doctrines of discovery and conquest, hinged on notions that Native cultures and ways of life and religions are inferior, looking at the guardianship and wardship principles that are features in colonial systems around the world. Other cases that took it from there as far as plenary power, and these doctrines have very clear anti-indigenous functions. They amount to a dark side to the law, of the law. And today, it's these very principles that hold us back in our country here, that keep us poor, that maintain these hard-to-solve social ills that we see in our communities here. On the other hand, this legal framework does, to be totally honest about it, it does contain some protective features at the same time. The doctrine of inherent tribal sovereignty is one of them that was laid down in the Worcester case by the Supreme Court, Cherokee Nation v. Worcester, that tribes possess in their self-governing entities with an inherent right of sovereignty. And secondly, that their relationship to the United States of our Indian nations is like a protectorate, a benign protectorate seen in international relations, that the government of the United States, the stronger nation, taking the Indian nations into the body politic under the protection of the United States government as a protectorate, does not giving the United States license to prey upon the tribes, to exploit the tribes, nor to oppress the tribes. So these are protective features of this federal Indian law framework here in the United States. And under these protective features that we do have over the last couple of generations, we have been able to witness the rise of our modern Indian nations, through the Indian self-determination policies, through the inherent doctrine of tribal sovereignty, through the protectorate notions. We've seen a very dramatic social movement here in this tribal sovereignty movement that has borne fruit as we look around the country here. And our legal strategy was basically to take the legal framework as we found it, with the protective features, with the dark side, and live with it. And the legal strategy of I and my colleagues, if we had one, was basically to focus on the protective side of federal Indian law and take that as far as we could go and coax the courts and coax the government into going under these protective features and simply living with the dark side of the law. And we've come, I think, a long way to our credit using that strategy. But the end result of that is, which I think is a relevant axiom here, is that the end result, though, is the rights that we have achieved are vulnerable rights. Because we have an inherent tension in our existing legal framework. On the one hand, we have these protective features. On the other hand, we have these dark side of the law. And these two elements of federal Indian law, there's an internal tension between the two. They are pitted against one another. You can't be a self-determining people on the one hand while you're hostage to plenary power, for example, on the other. The two conditions are incompatible. So we have an imperfect, I think, legal framework here. And so our rights are vulnerable because the Supreme Court can look to the dark side of the law anytime it wants to trim back our rights. We do have a hostile Supreme Court in our country. We've lost over 80% of our cases since 1985 before the Supreme Court. Currently, we have a lame duck president, a man that has done very good for our native people, but is now a lame duck. Our other forum is Congress, but that is a hostile Congress locked by gridlock. We hardly have any adults in our Congress, it seems, anymore these days. And as a result, I think that at this point, the door is barred to the full measure of self-determination here in the United States. It's barred by a hostile Supreme Court, a lame duck president, an ineffectual Congress. And we can, as I mentioned earlier, only advance so far under this legal framework here. And I submit to you, we've come as far as we can go riding that pony. To go any further, we're going to have to, we need a lifeline. And I think that lifeline is this human rights framework to take any more significant advances in our aspirations. And I suspect that other countries, you may have similar problems in your legal framework in your countries, despite your best efforts. If you still live under a legal system in other countries, New Zealand, Canada, Australia, other places in the world that contains these features from colonialism, despite your best efforts, you can only go so far in your aspirations. And then to go any further, you're going to have to do some significant law reform there. So the status quo under this existing legal framework is has simply one in our country. It's one of defense to react against divestment by the Supreme Court, threats from Congress, and so forth. And our legal framework then has not brought us to the promised land. And our aspirations for the full measure of self-determination, as that's robust self-determination as defined by modern international human rights law, is beyond reach. Against this current legal framework, and at least in the United States and possibly other countries, we can now see this brand new human rights framework coming our way. This is the one that has been created by this UN Declaration on the Rights of Indigenous Peoples. It was passed by the United Nations General Assembly in the year 2007. After 20 years of hard work by indigenous advocacy, indigenous pioneers that went to the international arena, worked long and hard, and never gave up, who are, I think, heroes that we're all indebted to. We owe a debt of gratitude for folks like Oren Lyons and many of the people that are in this room for their advocacy at the United Nations, because I believe this is a landmark development that has brought us to the brink of a brand new era for indigenous rights. 150 nations around the world have endorsed this UN declaration, making it, in my opinion, the new order of the day. It draws on standards that were pulled from a larger body of existing modern international human rights law, the UN human rights treaties, norms, and customary international law are pulled out and put into this document